Hi, my name is Yusuf, and 2 years ago I bought a house and made multiple fancy renovations. So I took a loan from Safi Bank to finance the cost of the renovation. 2 years later, I failed to pay the monthly installments to Safi Bank. And to recover the outstanding amount, Safi Bank decided to foreclose the land and all the items attached to my house, including my fancy stuff. So I don't think that they have the right to foreclose the items attached to my house. So let me ask you guys whether Safi Bank has the right to foreclose the items attached to my house.
Thank you for coming in, Mr. Yusuf. Now, regarding your issues, I'm going to give you a little bit about what is land. Now, land is found under Section 5 of the National Land Code, which states that land is all things that is attached to the earth and all things permanently fastened to anything attached to the earth. Now, here, the importance for you, in example, is defining land are such to determine the rights of the purchaser on certain items in a sale and purchase transaction, to determine whether a particular item forms part of the land or not, to determine the right of the charge of the bank to the land charge over to them as a security. All right, Mr. Yusuf, moving on, the things that are attached to the land may be called as chattel or fixture, like depending on their characteristics. Now, an important maxim I'm going to give you is quid acid plantator solo sedit, which basically means the nature of the fixture, which simply means anything attached to the land becomes part of the land. Now, there are two tests to determine whether an item is, a chattel or a fixture. Now, this is laid down in the case of Holland and Hodgson. In this case, a mill owner purchased some looms for his mill. He then attached them to the floor by nails driven into the wood. So basically, the court held that the looms had become fixtures and formed part of the land since they were then so attached to the land. Alright, back to the two tests that I talked about before. Now, the first one is the test of degree of annexation, and this test concerns the physical attachment of an item to the land. Even if the item is slightly attached to the land, it is considered a fixture. Now, if it stands on its own, it is a chattel. Now, the damage factor should also be used in this test to determine its state. Now, if there is damage when it is removed, it is considered a fixture. Otherwise, it is a chattel which can be moved. Now, this assumption can be disapproved, therefore both tests must be used. For the second test is the purpose of annexation. The second test does not concern how attached the item is to the land, but rather why the item is affixed. If the item is placed to improve the value or the utility of the land, it strengthens the probability that it is a fixture. Yet, if it's more for like enjoyment or for personal purposes, it is a chattel. Now, the goal of a chattel is to increase the value of land, then it is no longer a chattel, and it must be noticed that the purpose of annexation overrides the degree of annexation.
So Miss Surya, I've had renovations done, so I have custom made a fridge that looks like a kitchen cabinet, a special grill to be installed in between my kitchen and backyard for better ventilation, and I also have a hot water system to my house. Are these things considered fixtures to my house?
Yes, Mr. Yusuf, based on the items that you have explained to me just now, your custom-made fridge, the grill, solar hot water system, and water irrigation system, I would consider those as fixtures, as applying the first test of degree of annexation. Now, these items have been so renovated and attached to your house and the earth, the soil itself, through your water irrigation system. For your fridge, it was custom made to make it look like a cabinet, so it was installed into the house. Hot water system also installed into the water system in your house, and also the grill was placed between your kitchen and your backyard. So those are all fixtures. And like moving to the second test, which is the purpose of annexation, that you bought this big land, and even though these items that you've mentioned are considered like chattel, it's a presumption of the purpose of the items here. You use for your own enjoyment, and you wanted to have them renovated in because you wanted them to be there permanently. for the better enjoyment of your land and to improve its usefulness and value. So here I would say that yes, those items are considered as fixtures. Alright, Mr. Yusuf, I'm going to explain to you on a few exceptions that are available in the general rule, the case of Holland and Hodgson's here, to cater to certain circumstances that pertains to your case here. Now, this exception is related to the existence of a written agreement. It is in a circumstance where there is an explicit clause relating to the existence of a fixture and the restrictions imposed on the ownership of the fixture, and such provisions has clearly specified the limitations imposed on the ownership and the fixture. The relevant written agreement provided in the situation here for you is a hire purchase loan and a charge, which is like a relationship between a charger and a chargee. Here's a case that is similar to your issue, Mr. Yusuf. Wiggins Tea Malaysia Sendirian Berhad and Bahagia Trading Sendirian Berhad. It concerns a dispute between a charge and the owner of an object under hire purchase. In this case, a property was charged to the bank in which an offset printing machine was under hire purchase scheme was affixed to the property by to the floor by bolts. Now, the charger had failed in his loan repayment and the bank took proceedings to enforce the charge. Now, there was also a dispute whether the machine formed part of the property, was the subject matter there, and in the end it was held that the machine is a fixture and thus passes to the charge even if it were attached to the land after concluding the charge agreement, unless of course contrary was provided for in the contract.
So in the first issue that I proposed to you, where I took out the loan with Guitar Bank for custom-made fridge, and in the same year I also took a second loan with Safi Bank for the finance of my renovations, which included my solar hot water system, irrigation system, and in the second loan as security, I charged the land to Safi Bank. And 2 years later, which is now, I've failed to pay monthly installments to Safi Bank, and for them to recover the outstanding, they decided to foreclose my entire house and all the things that I attached and the renovations with it. But however, there were items belonging to Guitar Bank, which was the custom fridge under the first purchase loan that I took out. So the agreement entered between me and Safi Bank was a loan, and I charged the land to Safi Bank as security. So under hire purchase loan, the ownership of the item belongs to the bank, and the buyer, which is me, will only obtain possession until I paid full price of the loan. So since I have yet finished my installment payment, then Safi Bank could just retain the possession of land, which includes the items attached to the house. But this fact was not made to Guitar Bank regarding the second loan with Safi Bank, and mere impression is not sufficient to them. So therefore, since Guitar Bank has no knowledge of the second loan and I had charged the land as security, Safi is entitled to foreclose the land and all the items attached to it. So all my stuff is going to be gone. Sarah is a neighbor that I really hate. So she lives beside me and she excavated part of her land to build chalets. And as a result, part of her land collapsed onto my garden, damaging my irrigation system. So I want to take legal action against Sarah to recover the loss suffered. So can I or cannot not take action against Sarah for my loss suffered?
Hello, Mr. Yusuf. Welcome to our law firm. My name is Laisha, and it's a pleasure to meet you. By the way, before actually we start our legal consultations, I would like to actually to run through the fact with you just to make sure that I'm giving you the right advice. So it's stated here that you actually want to take legal actions against your neighbor Sarah for the loss suffered due to her land's collapse onto your garden, damaging your irrigation system, right? I see. I understand how it could be very stressful for you. So Mr. Yusuf, I'm going to explain to you in a very simple explanations. Okay, so based on the case of Corbett and Hills, we stated that whoever on a piece of land on everything extending outwards into the limitless skies and downwards to the middle of the earth, meaning that if you actually own the land, you own everything from the up and until the downward. However, unfortunately, Mr. Yusuf, the right in enjoying the land is actually not absolute, since once the land has been disposed of by the state authority to the land proprietor, the licensee or lessee, as per laid out in our national land code. So, Mr. Yusuf, according to the section 44 subsection 1 of the National Land Code, a person is entitled to first a right to enjoy the column of air space above the lands, second a right to support by the adjoining lands, and third a right to access to foreshore, river or public place. It is an exclusive, however it is not an absolute right, as it is subject to limitation in other provisions in the National Land Code and any written law in Malaysia. So enjoyment must be reasonable, necessary and lawful to balance actually the individual rights of enjoyment of the land against overall public right to actually utilize the land for common good. So Mr. Yusuf, after I check, your situation actually falls under the right of support. So the stateable sections for your situation right now is section 44 section 1b of the National Land Code. This section is regarding the right of support by the adjoining land, in which the landowner is entitled to have the right of support and for it not to be removed. So meaning that actually you are entitled to have the right of support and for it not to be removed by your neighbor, which is Sarah. Okay, this is to ensure that the right of the owner of the land, meaning you, is safeguarded, and this applies to neighborhood principles. The owner of the neighboring land must also take precautions for actions to not disturb or cause damages to the neighboring land and fulfill duty to support it. So actually, by applying the neighborhood principle, the right of support is actually a negative right, in that it is a right for you not to lose natural support from the adjoining land. So the adjacent owner has a duty to support and not to do something on his land or her land or any of her property that actually might endanger the property of others. So however, there are several conditions that must be fulfilled for you actually to entitled to have your right of support, Mr. Yusuf. Okay, see, these conditions include that your lands and your land and your neighbor land, which is Sarah, must be adjoining to one another. And next is your land must be in natural state and no additional support is given beyond what is on the land. Mr. Yusuf, I know this is quite confusing to you, so I'm going to explain to you with some cases that are similar to the situation right now. So in the case of Madam Cha Siam and Choi Kong Si, it was decided that by the court that natural state of land is when the land is unburdened with buildings and not weakened by excavations, as the right of support does not become a greater right just as when the buildings are built or the excavations are made on lands. So the fact of this case is in regard to the plaintiff claiming for damages is the loss of the last portion of the fish when the pond built on the state land under temporary occupation license caused water to pour into the abandoned mine nearby. However, it was then held that the plaintiff could only claim for such degree of support as the land is natural state, refer to the land in its natural condition, and shall have no right for additional support that is required by the reason of its weaker state. And because actually Hanlin already become a pond, thus it already being excavated, meaning that the plaintiff is not entitled for the right of support because she's actually not fulfilled the conditions of natural state of land. So applying to your situations, Mr. Yusuf, there are 4 conditions that you must prove to successfully claim this against your neighbor Sarah. So the first condition is your land must be adjoining to each other, and in your situations, you stated both of your land are situated to each other. You stated in here that Sarah is the owner of the land adjacent to your land. In these situations, Mr. Yusuf, your house suffered damages due to the activity being carried out by Sarah, where your right of support from the adjacent building has been infringed. You actually have a claims against Sarah for damages and loss of right of support and vice versa. This the first condition is fulfilled. For your second conditions, so your land must be in natural state for the second condition. So this is quite hard to fulfill. So actually, you have a water irrigation system, right, Mr. Yusuf?
I have an irrigation system because I love gardening. So what does the condition of my soil and the irrigation system have in common? Why are they related?
Okay, it's actually because under common law principle, every piece of land has an absolute right of support from adjoining land, and the land must be, however, the land must be in its natural state and unburdened with building and weakened by excavations. However, I'm sorry, Mr. Yusuf. However, in these situations, your land, I'm afraid your land is not in its natural state. Do you actually had installed a water irrigation system for the purpose of your gardens? Because excessive seepage from the existing system that went into the soil actually can cause waterlogging of the area. It's also lower the temperature and make the locality dam due to the presence of the irrigation water, and the fact that a volume of water carrying varying in amount from time to time on your garden for 2 years, showing that the presence of the water irrigation system only increase the weakened state of the land. Uh, like you already excavated your lane to actually install the water irrigation system, and the water irrigation system produce water and cause waterlogging and actually weaken your state of the land that already weakened because of the excavations, and applying the case of Maiden Chasiam and Chop Choi Kong Kong Si, I'm afraid that Sarah cannot be held liable due to your lane is not in its natural state and already weakened by the excavations. Therefore, Mr. Yusuf, I'm really sorry to say this, you are not entitled for support. Furthermore, applying the third conditions, Mr. Yusuf, which no additional support is given beyond what is on the land. You cannot expect additional support from Sarah land, and if your land is already proven to be in weakened state, your land which contained the irrigation system had no right to the additional support due to its weakened system state from the excavations and irrigation system. I'm really sorry, Mr. Yusuf.
So you're saying Sarah can only be sued when her actions or omissions result in loss of damage to support, not if she fails to provide new or additional support which was not in existence earlier. So the right support imposes a negative duty not to cause withdrawal of support to my land, not a positive duty for her to provide support to my land, thus referring to section 44 that you mentioned earlier and the cases that you mentioned. I have no rights to sue Sarah due to the land already in its weakened state and not in its natural state.
Anyway, thank you for consulting with our law firm. We love you have a problem, Mr. Yusuf.
My wife will leave me. What should I do?